Ebe anyị Mazi Nnamdi Kanu jekwara n'ụlọ ikpe n'ụbọchị tata bụ abalị 4 nke ọnwa Nọvemba n'afọ abụ 2025 dịka nsi wee wetaburu na mbụ na izuụka gara aga agwara m unu sunu na a ga-enwe ya bụ ịnọkọ n'ụlọ ikpe tata bụ ụbọchị Tuzdee bụkwalụ abalị 4 nke ọnwa Nọvemba. Ọkwa ka ejelu n'ụlọ ikpe ndị be anyị Mazi Nnamdi Kanu kwechikwa wee kwechisi ike wee sio na a ga-agwanatarịrị ya iwu ya dalụ kedu ebe ya bụ iwu nwaanyị dalụ dị gosi ya ebe ọ dị maka na ya ma na aka ya dị ọcha na o nwere ife ya mee ịmaka na onye ka anọkọta wee sịkwazie na o nwere iwu nwanụ nke ọ dalụ nke dị na sekshọn ebe nwanụ nke dị n'ebe nwanụ unu maka ka fasi akọnya bụ ife abụrụ na m lọya mana unu ya aghọta ebe m na-eje wee gụbagụsịa Mazi Nnamdi Kanu kwu na o nwere ife ya merụ eji wee na-ekwu na aga ekpe ịmara ya bụ izuụka gara aga ka o kwesịrị ịpụta ya bụ difensi nke a na-ekwu okwu ya mana maka na ọ na-esigo anya na ya bụ akwụkwọ ebute wee gosi ya bụ iwu ọ dara eji ekpe ya bụ ikpe o wee nesi ya sị na o nwere ife ya fụrụ n'ime ya bụ ife anụnwa na aka ya dị ọcha ma makwala m na o mechakwara wee dee akwụkwọ wee dega ka enwee ike ka gbuo ya bụ ikpe ahụ a na-ekpe mana ihe niile anụnwa o mere na mbọ niile ọgba ha chọrọ ịnenyere ya anya mana tata n'ụlọ ikpe ị ga-egezi ntị ka ịnụzie ife ndị ọkaiwu ya ma barista Aloyejimọfọ ma barista Maxwell Ọkpara na ọtụtụ ndị ọkaiwu dịkwa iche iche ka ịnụzi ihe ha kwuru gbasara ya bụ ụlọ ikpe nke ejere tata maka ya bụ Mazi Nnamdi Kanu ngwa ka anyị nene ya
limited wiggle room of a court of law, of the judicial. There is a lot of wide bat, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very, very disappointing. There's a thesis that has become intractable because Mazi Nnamdi Kanu is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this thing through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention on this case?
Well, of course, everybody is calling for that. It's not throwing in the towel. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empowered the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in court when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Okay, let's talk about the procedure today.
The procedure today?
The procedure is today.
Okay.
What next?
I will yield to one of my colleagues to discuss that with Maxwell Ọkpara.
Okay, actually, it's good for us to put the record straight. Mazi Nnamdi Kanu is not saying that he will not enter the case. Mazi Nnamdi Kanu said, under what law are you charging it? Going by the Constitution, there is absolutely no charge against him. Now tell me the law, the court should tell me the law upon which he's being tried. Now, my law is on so saying that whatever thing that you have to say should be ruled at the final written address, and it should be on a conviction to know whether you're supposed to be convicted. I'm not going to say no. There are thresholds, there are hurdles upon which you need to cross for you to reach that particular issue. And one fundamental issue there is that my law said we are talking about issue of extraordinary rendition, the way we are being brought back from Kenya to Nigeria. And he wants somebody to come and give evidence on that. There is nothing before him. And if you watch the motion of Mazi Nnamdi Kanu filed, Mazi Nnamdi Kanu said Federal High Court has given a judgment in respect of that, and also awarded 500 million naira against federal government in his favor. That judgment is in the court file. Court of Appeal, in their judgment, also gave a ruling on that. and make comment about that. The CTC of that judgment is in the court file. Supreme Court in their judgment also took judicial notice of that and they condemned that attitude. They are all in court file. There was a motion challenging the decision of the court where these issues are being raised. And Mazi Nnamdi Kanu made reference of the motion in the court file. And under the Evidence Act, Mazi Nnamdi Kanu is saying that under the law, court is obliged, is under obligation to take judicial notice of every document in their file. Yes. So asking him now to go and enter into a defense after giving evidence on that is a waste of time. Yes. That court is on its own supposed to take so much to raise this issue. Yeah. Court is expected to raise this issue. Now there is a charge before me. Please.
The law that I have contravened. Yes. You cannot ask me to enter a defense for a law that does not exist, and particularly the law that the Supreme Court itself has declared non-existent. So what will I be defending? We're in a country where our laws are written. This is not England where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they made chapter 45 of the criminal code. They didn't make it. But honorable, you will make that law. It's not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that the Mazi Nnamdi Kanu is completely right and within section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged in a court with a law that is in existence, not with a law that is not existent.
ụmụnne m unu anụgonu ka ya bụ ife si wee ga unu anụgonu ọtụtụ ihe dị iche iche ndị ọkaiwu ya bụ Mazi Nnamdi Kanu kwuru ma barista lawyer Ejimofo na ndị ọzọ gasị dị iche iche ndị nke agbala ajụjụ ọnụ unu afụgo na ọ bụrụkwanụ na Mazi Nnamdi Kanu achọrọ ịbanye ya bụ defense kama na ife ọka na-ajụ bụ kedu ife bụ ife ahụ ya melụ maka na ihe nnesigo onwere ife ya melụ ụmụnne m ana m asịkwa na ọ bụrụ sọ mụsa meke n'ihe nke anụnwa ka ọ gaa n'ọsọ ịsọnụ kedu ife ha na-egbukenela oge anọkwazi n'enu wee kagharịzịa ụbọchị ọzọ a ga-anọkwa na ya bụ ụlọ ikpe wee tinyekwa ya bụ okwu ọnụ ọzọ o wee bụrụ na ọ ga-adị na ọ ga-abụzi na mkpụrụ ụbọchị 5 nke ga-abụ Wednesday n'ọnwa Nọvemba n'afọ abụ 2025 nne m okwu otu aka si wee fịa wee sị ka m nwetala nya bụ update ka esi wee jee nya bụ ụlọ ikpe gbasara Mazi Nnamdi Kanu tata ngwa kaparụ ka ịgbasa anya bụ ozi ma nọla ọfụma ndị chọrọ udo kwudodere